Hi everyone, very good morning and welcome back to Grade B. So today we are going to start with our ministry related schemes, right? Few of the schemes were left. Apart from that, few of the legislative provisions were also left, right? So in this lecture we are just going to talk about the factual information that is needed from the perspective of reading your Ministry of Women and Child Development. We are left with some around 3 schemes. Once we are done with those schemes, we'll shift on to the organizations. We'll be talking about some autonomous organizations which are working under this particular ministry. Number one important point. And after that, we'll also be talking about few of the legislative provisions that are there for the protection of women. So all in all, it will be an important lecture from the perspective of your objective exam questions as well as subjective as well. Few of the data you can be using in your subjective examination as well. So now let's start with the scheme. First of all, there is a scheme. It is an old scheme, but there has been some changes. That's why we are reading about those particular changes. See, the scheme is related to adolescent girls. Correct? What will be the major changes under this particular scheme? Let's see it over here. So under portion 2.0, earlier, the scheme for adolescent girl, it has been revised. In the age group of 14 to 18 years in aspirational districts instead of school girls which are in the age group of 11 to 14 years as it was in the earlier scheme. Earlier scheme already said that we are going to include the girls which are in the age group of 11 to 14 years, but it has been revised. Why? Because in aspirational districts you guys already know that the development indicators are super low. That's why they wanted to support the girls who are in the age group of 14 to 18 years in the aspirational district. So that how easy a change has been over here. Now we already know what are the objectives of this particular scheme. The objectives are providing the supplementation related to folic acids, health related checkup, referral services, etc. These are the things that we are going to provide to our adolescent girls. Now next is what is going to be the nutritional related component. So nutrition related component, additional calories 600, protein, that is what they want to provide. Apart from that, there is another point that you should be having a care of, that is called as out of school adolescent girls. This is an important point, right? So this means the scheme also covers the girls who are not going to school. Very important thing, can be asked in a subjective questions. Hence, 2 to 3 times in a week, the non-nutrition related supplementation, health checkups, counseling, skill education, etc., public services, these will be provided to the girls who are not even going to the school. Right? So these are the provisions that we have for the scheme for adolescent girls. Some revision was there related to the eligibility in aspirational districts that we have covered. I hope that you are going to remember it. Now next point is our PM Cares for Children scheme. We all know that when PM Cares was launched during the time of pandemic, right? So I hope that, I believe that each one of you must have contributed towards it during the tough times of pandemic. Now, the funds which has been collected under PM Cares, they can be used for various purposes. One of the purposes here, and we are using it for the development of child. Let's quickly see through what all are the provisions, what all you have to remember, who are all the implementation agencies. See, the PM Cares for Children scheme, it was launched in the 29 May 2021 by our Prime Minister. What is the aim? So the aim is to support the children. Please be very careful about here. Eligibility criteria is very important. We want to support those children who have lost both of their parents or legal guardians or adoptive parents or surviving parent to COVID-19 pandemic. That means if you have lost any of your parents in the time of COVID-19 and now you do not have anyone to take your care of, then you will be eligible to support under this particular PM Cares scheme, right? PM Cares for Children. Now what is the objective? Very careful. What we want to provide over here is, first of all, we want to empower them with education. Apart from that, we also want to provide them health insurance empower them for self-sufficient existence. Now, how we are going to support that? Now, for that, there is a financial support. I'm going to tell you what is the financial support. First of all, let's see who all are the implementing agencies over here. So, PM Cares for Children. PM Cares for Children means the scheme is going to come under the Ministry of Women and Child Development at the central level. Please remember this. Remembering the name of ministry for any particular scheme is the foremost objective, right? You should be remembering this first thing. Next is Department of the State, which is dealing with juvenile justice at the state level. It is going to be an implementing agency at the state level. Finally, we have district magistrates at the district level. The scheme is going to create a corpus of 10 lakhs for each child when he or she reaches the age of 18 years. Now, please be very careful. We are creating a corpus of 10 lakhs. That means for every child, there are 10 lakh rupees. What we are going to do with this particular 10 lakh rupees? So, there are two components. What are two components? Number one component, you are going to see it over here. See in the benefits. The corpus is going to use a monthly financial support. We are going to provide a monthly financial support or a stipend to the child from starting from the 18 years of age for the next 5 years. See, we all know starting from the 18 years of age, there are so many expenses which a child needs, right? What kind of expenses they need? There are education related expenses, there are obviously existence related expenses, and so many more. So for that, monthly stipend will be provided. Out of where? Out of the 10 lakh rupees corpus that we have created. And once the child achieves the age of 23 years, right? Once he achieves the age of 23 years, he or she will get the corpus for once lump sum payment. Now, any money of his will not be kept with the government. He will be provided with all the lump sum payment that was being generated, right? So, this is your PM Cares for Children. Lastly, there is a online platform as well. Just a little piece of information, PM Cares for Children.in. So any scheme related thing, any scheme related knowledge, education related materials, all will be posted over in this online portal. So this is how simple PM Cares for Children was, right? Now next scheme is the Unnati initiative. We are going to see this. It is a new initiative of, again, Ministry of Women and Child Development. Right now, because we are reading Ministry of Women and Child Development, it is easier for you guys to remember. But remembering it in the examination is the most crucial part that we should be looking forward to. Yeah. Now, one by one, I have oversimplified it, right? So you will just have a look on over that information, that is what is crucial for you. Now next thing, see over here, Unnati is going to be in the form of scholarship. What we are providing under Unnati initiative is scholarship. It will be operated through National Children Fund. What is the agency? I understand that, correct. So I have tried to simplify it, but still please understand, we also have a limitation over here, because the examination you guys are approaching for, it is they are very unpredictable in nature. You never know that what kind of questions can be asked. So we are also in a fix, right? We also try hard to find a balance between what to include and what not to include, correct. There are some we seem like that, okay, it might be an unnecessary piece of information, but the examiner tend to ask such kind of questions. In the past previous examination trend, we have found out that they try to go in depth for the ministry related things, but still by looking at the requirement of you guys, I have tried to simplify the document so that at least now in this I have tried that I will not be leaving anything which is important and which needs to be covered. So that's why length of document still a bit much, but still I guess this is coverable, and this is This is what you can guys expect, that at least this much is so you have to read. This is non-negotiable. We cannot go beyond this, means lesser than that. Now let's see, Unnati, it is going to be in the form of scholarship, right? So National Institute of Public Cooperation and Child Development, this particular agency, it is implementing this particular initiative of Unnati. What you have to remember, that it is a scholarship related thing, number one. Number two, it is being operated through National Children Fund, where the funding is coming from the National Children Fund. You have to remember the implementing agencies. Now let's quickly see what are the objectives of the scheme. We have tried to keep the objectives as simple as possible. Now see over here. First thing first, you want to improve the academic performance of the children who are living in the child care institutions. Now, number first thing, child care institutions are needed to be run as per the Juvenile Justice Act 2015. We are going to cover this Juvenile Justice Act as well. Fine. So, at the end of this lecture, I have tried to incorporate all the legislative pieces of information that is required for in order to complete your understanding. So we are going to cover them as well. See over here, who all are covered? So the children who are studying in class 9th to 12th till the attaining of age 18 years or on completion of 12th class, whichever is earlier. Very important. So if a child is studying in class 12 but he has already exceeded the age of 18 years, then he or she will not be eligible. Whichever is earlier, those particular child will be eligible. 300 scholarships will be provided in each class. That means 1200 scholarships in a year will be provided. The applicant seeking scholarship, they should be sheltered in the child care institution. That means the Unnati scholarship initiative, it will be given to all those children who are in the child care institution, not outside of it, right? So we have made this scheme for only those children who are in the child care institution. Now let's see, CCI should be registered obviously under the Juvenile Justice Act. Only after that we are going to provide them this particular scholarship benefit. Now few of the eligibility requirements are there with the applicant as well, who will be eligible to get the scholarship. Now see, the number of scholarships are limited. There are just 300 scholarships. So applicant should have scored minimum 55% marks in the final examination of previous class. 75% of the attendance is compulsory, and obviously they should be having a Aadhaar link saving scheme. 50% of the scholarship is secured for girl students. 50% you have to give to the girl students, that you cannot negotiate with. Now next thing, last amount is the scholarship related amount. So scholarship related amount is total 13,000 rupees will be provided in a year. What is the total amount? 13,000 rupees scholarship will be provided, 1,000 rupees per month per child, and along with that 1,000 rupees for the study material. So total 13,000 rupees of scholarship in both the standards, that means 9th, 10th as well as the 11th, 12th. This is going to be the scholarship amount. Now moving ahead and talking about the autonomous organizations which are working under the Ministry of Women and Child Development. Again, an important piece of information what you should be remembering is, see, because we have completed the ministry related schemes, now at most of the times or in the most of the scenarios you are going to see that okay, this is the institution which is going to implement this particular scheme. So you should also be remembering about that institution. Only these three pieces of information which are given over here, that are more than sufficient. Please do not try to go beyond than that. Fine. Here what we are going to see, the name of the institution. Obviously one piece of information is common, that all of them are working under the Ministry of Women and Child Development. When they were developed, what is the aim of these particular institutions? Once you know all of that, it will be easier for you to understand if any such kind of question appears in the examination. Just wait for a second. Yeah. So let's see first. First we have National Institute of Public Cooperation and Child Development. Now what is the function of this particular institution? Function is to provide training to the functionaries under the Integrated Child Development Program as well as the Protection Scheme. When was it established? It was established in 1966. Then we have National Commission for Women. I have a question from you guys. National Commission for Women, it is a constitutional authority or a statutory authority? So that is my question, that National Commission for Women, whether it is a statutory authority or a constitutional authority. You have to tell me if you are watching this particular lecture after it is conducted live, then please write in the comment section that what do you understand by a statutory organization or a constitutional authority, and which one of them is the National Commission for Women. So this is going to be your work. You have to find it out and you have to write me down that particular thing. So National Commission for Women, set up in 1992. What is the function of this commission? So it is going to review that the constitutional and statutory safeguards which are provided to the women, whether they are complied with or not. Any kind of problem that women might be suffering, they have to facilitate grievance redressal as well. And apart from that, they have one more function. They advise government on the policy matters. If there is anything related to women, they are asked that, okay, dear National Commission for Women, please apprise us about this particular piece of information. Next, similar kind of organization, but this particular organization is for the protection of child rights. Fine. National Commission for Protection of Child Rights, established in the March 2007. Again, the same question persists, whether it is a constitutional authority or a statutory authority. You guys have to tell me. It is very important. Fine. Find out. National Commission for Women, National Commission for your Protection of Child Rights. Both of these. What is their organization type? So this was also established in the March 2007. Please remember what is the establishment date. What is the work they do? The similar kind of work what National Commission for Women does for the women. See over here. They see whether all laws, policies, programs, mechanisms are in accordance with the child rights. That means whatever rules and regulations, protection, etc. they have been made for children, whether they have been followed or not. That is the work of your NCPCR. Next is CARA. Central Adoption Resource Authority. Now, I would like to tell you a piece of information over here. CARA, that means Central Adoption Resource Authority. It has got its statutory authority related status. It is a statutory authority. Fine. What are the statutory authority? So, authority which is established by a law, that is called as the statutory authority. There has been an act which is passed by the parliament because of through which it has established. So it has got a statutory authority recognition by the Juvenile Justice Act. So that is, I guess, an important piece of information. It is a factual information and both of these are not related as well. So again, see, anything which you think that, okay, I will not be able to provide a guess in this particular question, all of that piece of information becomes important, right? So Central Adoption Resource Authority, it is a nodal body for the adoption of Indian children and it is mandated to monitor and regulate the country as well as the inter-country adoption. Whatever adoption related things that happen in India is maintained and regulated by the CARA, Central Adoptive Resource Authority. Apart from that, in this CARA, it has got its statutory status from the Juvenile Justice Act. So please remember this piece of information. Next is your Central Social Welfare Board for promoting social welfare activities, etc. Not very much important, not remains in the news so much, so you can just have a look at it. Next is Rashtriya Mahila Kosh, again an important piece of information. It is for socio-economic development of women. It provides loan to NGOs, microfinance institutions, right? So that is the same. Now we are going to shift to as per me, this is the most crucial part, right? We are going to see that what have been the legislative provisions, and believe me, when you have completed the understanding of schemes related part, you should also have the understanding that what are the legislative protections that are granted to the women, and not just because of your exam perspective, it can be watched by anyone, and it just tells you that in society what are the normal rules and regulations which protect the rights of a woman. Now see over here, we are not going to see the whole act, obviously. We are just going to see the important provisions which are important from our exam perspective. Now, first of all, in the line, I have Maternity Amendment Act. So, this particular act was brought in the year of 1961 originally, but then we amended it. Why we amended it? Because there are various situations, the times have changed. Now we need more laws, more protection laws for the women, and by following up with that, we have brought in this particular amendment act. Now we are going to see that what are the eligibilities for women, what are their what they can get out of this particular amendment act. So first of all, where does the act applies? Very important. It act applies on all organizations which are employing more than 10 people. So any organization which you see, if it is employing more than 10 people, then they have to comply with this. As per this provision, to be eligible for Maternity Benefit Act, you must have working in an organization for a minimum period of 80 days. It cannot happen like today you came and the next day you are asking your benefits under the Maternity Benefit Act. No, it will not be eligible. First, please work for 80 days and then ask for your benefits. That's what our act says. It enhances the duration. Now, the period of leave that is eligible for women is 26 weeks. Yes, issue of period leaves as well as this. See, there are always two sides of the coin, right? So one side is obviously there are peculiar needs of women and government is respecting them, government is creating enabling laws, but at the same time in our world we have corporate people or we have private organizations which are run with the motive of profit, right? They want profit. Now they have to see, just look at the amendment. Obviously, it is important for the women, but at the same time, it is imposing an obligation on the employer to employ women and then grant them a leave of 26 weeks, right? 26 weeks, that is also a paid leave. So that creates a financial burden on them, and I'm not very sure, and this has been reported as per the newspaper that this is also a leading cause why employers not prefer hiring women. That is wrong in on so many fronts, but let's not discuss it. It is a debatable topic, right? There are always two sides of coin, but it can be managed. Fine. Now next, see, however, for those women who are expecting after two children, see, you already have two children, now you are expecting a third children, in that case the maternity benefit leave is just unaltered and you will get just 12 weeks of maternity benefit. The paid maternity leave they can avail 8 weeks before the expected date and remaining 18 weeks later. That is a lesser important provision that you can totally skip, but I have not skipped it because you never know, hence I have included it. It extended the benefits of adoptive as well as the commissioning mothers by providing them 12 weeks of maternity leaves. Now understand it over here, this is an important component. For adoptive means if you have adopted a child below the age of 3 months, then you are an adoptive mother and you are eligible for a maternity leave of 12 weeks. Apart from that, what is a commissioning mother? So we all have heard about surrogacy, right? So if anyone who is becoming mother by through surrogacy, route of surrogacy, then in that case she will be called as a commissioning mother and she will be eligible for a leave of 12 weeks. Understood? Now next is leave for miscarriage. If there is a miscarriage, then 6 weeks leaves will be allowed, right? And apart from that, through the amendment, there is also a creche facility. If you are working in an organization, correct? Obviously you cannot leave after 26 weeks, you cannot leave your child at home. So this was a provision that every organization which is employing 30 or more people, they have to employ a creche facility as well. But after the amendment, this requirement has been changed, and now every organization which is employing 50 or more people. So from 30 it has been made 50. Few relaxations have been given to employer as well. So any organization which is employing 50 or more people, they have to provide a creche facility, and women employed can visit the facility 4 times, right? So this was this piece, just this line, this question was asked by UPSC as well, right? The same kind of lines. So you can just understand that what we are reading is of utmost importance, and we cannot use to skip this. Now next we have Sexual Harassment at Workplace Act 2013. One provision under this particular Sexual Harassment Act is important, right? So we are going to watch that, and apart from that, this is going to provide you the general understanding how this act is going to protect the women. So obviously at the workplace also women do experience kind of sexually context related the acts, right? And we need to provide them the protection. So with those intentions, earlier Supreme Court came with the Vishakha guidelines, and after which I'm just mentioning you this thing so that you remember what does these guidelines were all about. Don't go into the depth. Again, my disclaimer, this is just a piece of information for you. So one Supreme Court came with Vishakha guideline, and after those guidelines government came up with this particular act. Under this particular act, it was enacted so that we can provide a safe working spaces for our women, because we respect that women have the right to equality and no one has got an upper hand. So act covers all the women. Now this is very important, irrespective of their age or employment status. That means what? Any women who's working in an organized sector or an unorganized sector, a woman who is working as a manager, or a woman who is working as a construction site labor, both of them are equally involved in this particular act. Protection will be granted equally. No discrimination will be done. So remember this, all women are covered under this particular act, whether they are under organized sector or unorganized sector. Next is, in order to ensure that we are having a effective implementation, see sometimes what happens is we do not know that where to complain, correct? So for that you will be seeing that there are so many helpline numbers, so many online platforms. So going on the similar line, government has established a she box. Please remember the short forms, because these are the short forms that tend to get asked. So she boxes, it is an online complaint mechanism called as a sexual harassment electronic box. If anyone who's feeling like that she has been harassed at the workplace, she can complain on this particular online tool. This is being granted. Now this was a provision I was talking about. Again, an important provision. What we are talking about in it is, first you have to, every office, those who are employing 10 or more people, they have to form a internal complaints committee. That committee, the complaint has to be made within 3 months from the date of the incident. For a series of incidents, it has to be made within the 3 months from the date of last incident, and inquiry by the ICC needs to be completed within the 90 days. What is the ICC? ICC is the Internal Complaints Committee. Also, let me tell you that it is the responsibility of the employer to let the female employee know, female as well as male employee, that there is a Sexual Harassment Protection Committee or the Internal Complaints Committee in the organization, and that particular committee should also should be having the women representation as well, so that any women can go and can approach that particular committee in the times of need. So please remember two things over here. Number one is the she box, right? That is an online complaint platform where you can complain. Apart from that, which organizations need to form a internal complaints committee? This is also a piece of information, and I do not think that you will be needing an extra effort to remember these. These are super easy. You can just remember them. Next, if there is a punishment as well, minimum 1 year in jail with a fine, along with the fine, that is the punishment, right? And if also aggrieved woman, if she is not satisfied with the verdict of internal complaints committee, then she can approach the court within the 90 days. So that route is also allowed. You are not barred from this thing. Now next is Protection of Child Marriage Act. So when I was in 11th or 12th class, right, and I was not having the information about such kind of acts exist, and I have seen that one or two of my acquaintances in their community, the practice of child marriage was very common. Fine. So I used to think that at least this piece of information I always had, that child marriage is not allowed. Correct. So I thought that why these people are not getting punished. Correct. So that was the question I always had in my mind, and by reading this particular act, this somewhat clears, but at the same time, not just having a act is not sufficient, right? There needs to be proper implementation as well, and child marriages, they are not very easy to protect with, because in the first place many of the people, they do not complain. Correct. So let's see what are the provisions under Prohibition of Child Marriage Act 2006. So this particular act replaced the Child Marriage Restraint Act, which was there in the 1929. At that particular time, the ages were completely different, right? Till now, so we are talking about that we should be increasing. There are amendments about this particular act. There are talks of the amendment that we should be increasing the minimum age for marriage for girls as well at the age of 21 years. So this is not has been done yet, but yes, the government is in the process in doing this. So Prohibition of Child Marriage Act, it allows for child marriages between a boy, not child marriage, it allows for marriage between a boy who is above the age of 21 years and a girl who is above the age of 18 years. If the boy as well as girl, if they are below that particular age threshold, then that will be considered as a child marriage. Now there will be a fine. The male adult that is above 18 years of age contracts a child marriage, then he shall be punishable with the rigorous imprisonment for 2 years, as well as there will be a fine of 1 lakh or both. Parent or guardian, they will also be punishable with the punishment of 2 years as well as the fine of 1 lakh or both. Now one more thing over here, that is if the lady thinks or the boy thinks, it could be on the both ways, if they think that the child marriage that was conducted is not right, they want to get out of it, then they can, even if they have attained the age of majority, they can approach the court, and such marriages which happened when they were child, they are considered as void ab initio. Void ab initio means they are completely null and void. They do not have any existence in the eyes of law, and they can always be what you can say, removed. So the next piece of information that we have is on Protection of Women from Domestic Violence Act 2005. So by including this particular piece of information, I just wanted to tell you that there is such kind of act which exists, right? We all know that what domestic violence is, so no need to explain it over here. Just the provision against whom complaints can be filed. So these are the people against whom complaints can be filed. Any adult member who has been in a domestic relationship with the women, relatives of that husband or partner, includes both male and female relatives of the male partner. Against all such people, the complaint can be filed. At the same time, please see the applicability. This is applicable on the protection of wife. At the same time, this is also applicable on the female live-in partners. So live-in partners, they have also been considered as a category in order to protect from the domestic violence. So the protection has been granted to the live-in partners as well. So these were the two things that I wanted to tell you under this. Now we are going to see the next, that is called as the Dowry Prohibition Act 1961. There are so many social issues against women, and it is really a bizarre condition. Now see over here. First of all, the act extends to whole of India. Asking or giving of dowry can be punished with the imprisonment of up to 6 months and a fine of 15,000 or the amount of dowry whichever is higher. Imprisonment can also be extended up to 5 years. So that are the problems over here. Now again see, there are two cases in dowry. First of all, one case is you just take the dowry and all that shit, right? So what you do actually is there is a punishment. After that, sometimes what happens is, even after taking the dowry, there is a continuous harassment of the women, and it also sometimes leads to the death of women, correct, in the cases of dowry. So in such cases of heinous crimes, the accused will be tried under the Indian Penal Code, under IPC. That means such act just defines that, okay, what is the punishment for the dowry, but if the dowry case is combined with the other heinous crimes like the murder, then in that case you will be punishable under, you will be tried under the IPC. Now next is indecent representation of the women, 1986. It came in, amended in the 2021. What does indecent representation means? So I hope that you all understand morphed images, right? Presenting a woman in any indecent way, whether in your writings, whether in your paintings or in your photos, etc., etc. If a particular woman has got issue with that and she registers a complaint, then that complaint is going to be registered under this particular act. It defines that the depiction of any manner or figure of women, her form, body in such a way that having the effect of being indecent. Now the women about whom you have represented in such a way, her thought will be mattered over here. Her thoughts will be taken. If she considers that as it is indecent and she wants to file the complaint, then she can obviously. What are the punishments? So first conviction, 3 years of imprisonment as well as a fine between 50,000 to 1 lakh, and next conviction imprisonment not less than the 2 years, right? So these are the convictions that you have. Next is a very important act. Whenever child protection comes up or whenever the child welfare comes up, we always talk about this particular POCSO Act 2012, and many times we all know that what is POCSO Act, but at the same time we do not know what are its provisions. So it is very important not just to know the name but also the contents of the particular act, and this is going to help you in general as well. So POCSO Act, it was enacted to protect the children from offences of the sexual harassment as well as the any kind of sexual assault. Now the act defines as a child, very important thing, a child is a person who is below the 18 years of age. We have not kept a differentiation of adolescent or a child, etc., etc. If a crime has been committed on a child, then if she or he is below the age of 18 years, they are going to be considered as a child under the POCSO Act. Number 1. Next is Act defines different forms of sexual abuse, penetrative, non-penetrative assault as well as the pornography. Everything is covered and everything is punishable under this particular act. The act also, apart from this, apart from punishing all of that, the act is also a bit sensitive towards the child. So the police officers, all those police officers who are involved in the investigation with the child, they have been told to adopt a particular what you can say way of investigation, right? And the act mandates the investigation is to be completed within 2 months and trial should happen within the 6 months. There is a time limit that has been imposed. You cannot go off with this particular time limit. The act states that what is a sexual assault? Sexual assault will be considered as an aggravated sexual assault if the child is mentally ill, right? Please understand, aggravated sexual assault, penetrative sexual assault, in these kinds of assault the punishment is a bit higher. It is quite much higher. And the thing that why these particular acts have been made so stringent is so that we can control the crime which are happening against the children in our society. But the sad reality is, instead of controlling the crime, now the people who are doing such kind of crimes, now they are doing murder of children as well, so that there is no witness, or there should not be any evidence left. So that is what to say. So if the our act states that a sexual assault will be considered as aggravated if the abused child is mentally ill, when the abuse is committed by a person of the armed forces or security forces or a public servant, or if the person is in a fiduciary relationship. Fiduciary relation means in relationship of trust, correct? A family member, a police officer, a teacher or doctor, or a person management, whether government or private. So if you are having a position of trust and after that you commit such kind of crimes, that will be considered as the aggravated crime. So it prescribes a rigorous imprisonment of term which shall not be less than 10 years, but it can also extend up to life imprisonment. So that much how punishment has been given for under POXO Act. This is considered one of the stringent. It also makes mandatory. Now this is an important provision. Not just the person who has committed the crime, there is a punishment obviously against that person. But if you know that a crime has been committed against a child, you know about it, and even after that you did not report such crime, then there is a punishment against you as well. It is making the legal duty of a person to report the sexual abuse if he or she is aware about such kind of abuse. In case he fails to do so, he can be punished with the imprisonment of 6 months or a fine. Now for example, if the parents knew about the sexual abuse of a child, right, and they did not report it, then they are also punishable under the POXO Act. A very important piece of information, what you can say, way ahead of its time and important as well. So please remember this. If a person commits the penetrative sexual assault on a child below the age of 16 years, he will be punishable with the imprisonment of 20 years to life. Now you can see, under POXO Act, the consent of the person does not matter. If the person is below the age of 18 years, then the consent of such child does not matter. Correct? Whether he consented to this particular act or he does not, you will be punishable under the POXO Act. Now, important initiative called as the POXO e-box, similar like the she-box that we have, right? POXO e-box, it was launched in 2016. It is an online complaint box for reporting about the child sexual abuse. It is a National Commission for Protection of Child Rights initiative. Important, important, important. I also asked from you guys that NCPCR, National Commission for Protection of Child Right, it is a constitutional authority or a statutory authority. Nobody has given me the answer. Nobody. National Commission for Women, that also I asked whether it is a statutory authority or a constitutional authority. I am very sure that in one of my lectures I must have told. Okay? Are you very sure about it? Are you very sure about it? What about others? So next we have the Juvenile Justice Act 2015. Juvenile Justice Act, please see some of the provisions. Some of the provisions, good. Gaurav. Now see over here, some of the provisions of this particular act is very important. Whenever we are talking about the protection of child, Juvenile Justice Act is an important piece of information. First see over here, The Juvenile Justice Act, it was amended in 2015 and it allowed for children in conflict with law to be tried as adults under certain circumstances. So under Nirbhaya case, there was one particular person who was a criminal who committed that particular heinous crime, but because at the time of committing the crime, he was below the age of 18 years, the severity of punishment to that particular person was reduced. And there were obviously very much uproar about this, and after that government realized this, that the crime can be committed by a child and that is a heinous crime, right? So if you have committed a heinous crime and if you are in the age group of 16 to 18 years, then you can be tried as a adult. That means the rules and regulations, the legal way will be applicable to you on the basis of as an adult. So it defines as a child who is under the age of 18 years, right? Amended Act, it distinguishes the children between the age of 16 to 18 years. If they have committed a heinous offense, then they will be tried as a child. There will be no, what you can say, leeway or any kind of protection that can be granted to them because they are a child. No, if you have committed a heinous crime, you have to take in whatever the consequences are. Fine. Now next thing, heinous offenses. What are the heinous offenses? Any offense will be treated as an heinous offense if it involves a punishment of minimum 7 years, right? Most of the times it is rape as well as the your murder related cases, what you can say, kidnapping and murder, etc., etc. All these are called as the heinous crimes. Now next is, it mandates setting up juvenile justice boards and child welfare committee in every district. When I was discussing the scheme, I at that particular time also I told you, please remember, the juvenile justice boards needs to be established in every district. And I do not remember, but one of the examinations this particular question was asked, right, with the same piece of information. So it is important for you guys. Next is, Central Adoption Resource Authority was granted the status of the statutory body by the virtue of this particular act. A distinct piece of information hence becomes important for us. Now the last topic for today is the Hindu Succession Act and the amendments that are there under the Hindu Succession Act. Again, an important piece of information, Hindu Succession Act 1956, it was amended in 2005, allowing the daughters an equal share in the ancestral property. Now what is the history? So there are two schools of thoughts in India. One is Dayabhaga and the other one is the Mitakshara, right? Dayabhaga, Mitakshara is applicable in the rest of the India and Dayabhaga is prevailing in the West Bengal, Assam, Tripura and most parts of the Orissa. Fine. Now we are going to see that what is the difference in a shortest way possible. Along with that, we are going to see that what has been the amendments brought out in the year 2005 and what are the rights of the girl child. Now see over here. As per the Mitakshara, see, the joint family property goes to the group known as the co-partners. The allocation of partners' property is based on the by birth. Hence, the joint family property at the time of partition, it can be converted as a separate property. Therefore, in Mitakshara school, sons have an exclusive right by birth and female cannot be a member of the Mitakshara co-partnery, right? That was the earlier provision under the Mitakshara school of law. What was happening under Dayabhaga? So let's see, under Dayabhaga, when the father is alive, sons, they do not have any co-partnery right, but they acquire it on the death of the father. Once the father is dead, after that you can acquire such kind of rights. Now, okay, fine, that was just a limited piece of information that we needed to have. Now we are going to talk about what have been the amendments that are brought in the year 2005 after obviously a Supreme Court landmark judgment. So Hindu Succession Act 2005, it removes the gender discriminatory provisions which were there in the earlier act of 1956, right? Now what are the following rights given to the daughter? Daughter of a co-partner shall by birth become a co-partner in her own right as equal to as a son, right? Very important provision. Daughter has the same rights in the co-partnery property as if she would have been a son. No discrimination allowed. Now what about, there are few of the questions that we need to answer over here. If a married daughter is there, then she has no right to shelter in her parents' house. However, she will have a right of residence if she is deserted, divorced or widowed. In those particular cases, she is going to have a right. As per the Amendment Act, every daughter is considered as a member of her father's HUF, whether she is married or non-married, right, unmarried. In this particular case, we were just talking about the right of shelter, whether she can stay in her father's house or not after marriage. But in the HUF, in the business, she is having the right, and she can even be appointed as a Karta. So you all know that Karta is the main head of the HUF. So if she can be appointed as a Karta, obviously she has got the co-personary rights. Now there are few of the peculiar questions that we need to answer, and these questions they can form a statement based question, very short questions. So if property is ancestral, then what will happen? We are talking just about the women rights. So Succession Act says that a daughter of a co-partner shall by birth become the co-partner in the ancestral property. That means whether you are married, unmarried, you are having a equivalent right in the property of ancestral property as well. If the father dies in state, that means a father dies without any will, in that particular scenario also women is going to have the equivalent right as like just her brother. Next case, if the daughter was born or the father was died before 2005, before the amendment, so in that case also it does not matter, daughter will going to have the same right as a son to the father's property. Ancestral property, same rights, right? If the father dies without a will, no issues. Girl is going to have the same rights. If the father was born, if the father died before 2005 or the daughter born before 2005, in that case also the same rights will be there. And lastly, if the property has been self-acquired by the father, in that particular case there is a little bit of change. If the property was self-acquired by the father, then he has got the right to gift it to anyone, and here the daughter is getting a weaker right. So daughter is a weaker in this particular case. Father has the right to give the property to anyone, and daughter cannot raise any kind of objection. So with that, we have completed Ministry of Women and Child Development along with all the legislative provisions as well as organization. I hope you must have liked this lecture. Please do not forget to like this video, and thank you so much. And the questions I have asked, please do not forget to answer them. Thank you.